Well, again, here we are going to talk about legal issues in industrial psychology. Employment decisions, hiring and firing, have some implications, right? So, turns out that prior to the 1960s, it was not illegal. Discrimination was not illegal. There was no, right? Therefore, of course, cronyism is now illegal, right? Yeah, whatever. Okay, so before the 1960s, you could just hire or fire anybody at any point for any reason without any legal ramifications. Well, clearly those things have changed. We've got the Civil Rights Act, which created the Equal Employment Opportunity Commission, the EEOC. The EEOC in '78 printed out the Uniform Guidelines on Employees, so blah 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 blah. But EEOC guidelines. In 1987, the SIOP, the Society for Industrial Organizational Psychology, put together a document to help companies navigate the legal framework, okay, and how to hire and fire in ways. There is this construct in that overseas. I am not a lawyer, all right? Don't pretend to be a lawyer. But employment at will is a common law element of common law. It was brought over from England actually during colonial time, and the idea is that any employer or employee has a right to terminate the relationship at any time at all for any reason. So this is the fundamental common law notion of how employment contracts work. But in recent years, we find people have been suing for wrongful discharge, etc. So technically, employment at will is still the common law fundamental default. Specific contracts can, in fact, invalidate this idea. Okay, and in particular, contracts which then implement this just cause concept. Okay. So much of the legal work, legal issues in industrial psychology um, revolve around this concept of adverse impact. It is sort of like, in order to say something is discriminatory or discriminative, you need to establish adverse impact. And it's just a mathematical rule where basically what they're going to call the 80% rule of thumb. Although, courts are free to this is just a guideline. This is not a rule or anything, and so courts can come down on any side on this at any point. But the idea is that the selection rate of the highest selected group and the selection rate of the group in question, the group in question must have 80% rate of the one that's highest. So if you really feel like doing the math, there's two examples right here. The top one is non-discriminatory and hence has no adverse impact and is therefore considered non-discriminatory. And the bottom one is considered to have adverse impact and would therefore be considered discriminatory. So in a discrimination case, here's what's going to happen is a plaintiff is going to demonstrate, oh my God, here's some Latin, prima facie case on the face of it that shows adverse impact. Generally going to use that 80% rule. The defendant in this case is probably going to be the companies that fired or failed to hire. Can argue the stats are partial data, they're interpreted incorrectly, it's the wrong data, etc. Well, if adverse impact is in fact totally identified, the company can then argue, you know what? It's okay to have this adverse impact if you can show that it is, I love this phrase right here, a bona fide occupational qualification. I like that. Okay. And so what we find is that as long as, even if it is discriminatory, if it is employment related, then it is okay. And so in an interesting test case, Diaz versus Pan Am, Pan Am Airlines. I know some of you are too young to remember Pan Am. Used to be the major airline in America. Anyway, Pan Am. And so Diaz was a male and he wanted to be a flight attendant and they said no. And Diaz said, hey, and demonstrated adverse impact. It was pretty straightforward, easy to do. However, Pan Am says, look, being female is a bona fide occupational qualification, because what happens is flight attendants need to be nurturing, passengers prefer a nurturing flight attendant, and therefore it's a bona fide occupational qualification. But the court came down and said, no, I'm sorry. The main function of a flight attendant is safety. Comfort of passengers is secondary, and therefore gender cannot be considered a bona fide occupational qualification, since that is only a secondary function of flight attendants. Okay? Interesting, interesting. Affirmative action was or is a practice employed by organizations, very, very controversial, as I'm sure you've heard, to increase the number of minorities or to protect our protected class members. And so the purpose is to address historical discrimination. It is not a quota system. Now, quota systems are older, had very big issues. And so they were popular for many years, but they have been come into question, first one being Bakke versus the California Board of Higher Education, Bakke being a white student that was rejected by the California Board of High, University of California. But more recently cases more recent cases in affirmative action. Gratz versus Bollinger, and this is at the University of Michigan, where there was, two Caucasian applicants. I believe they were both male. Two Caucasian applicants that said they were denied admission because the university's admission standards at the undergraduate level included essentially a free 20 points given to minority applicants. So if you're a minority applicant, you can get 20 points. If your GPA is here, you get this many points, and this many points, and this many points. And so the Supreme Court ruled against the university and for the plaintiffs because awarding this global points ignored individual differences and individual qualifications. Meanwhile, Grutter versus Bollinger must have been busy that year. The law school at University of Michigan was sued by a Caucasian female who said she was denied based on racial preferences. But in this case, the Supreme Court came down and sided for the university, saying that diversity was a compelling interest for the law school, that having diversity in the law school was valuable in and of itself, and therefore a valid criteria for selection. Interesting. Interesting. Different courts, different opinions. Yeah. Hey, you, where are you at? There you go. A couple of other notable cases. Oh, I'm messing my things up. I'm sorry, y'all. I can't get this stupid thing. There it is. Okay. They in a similar way to the law school in Michigan, it was in Chicago where it was a white police officer arguing against their hiring practices, and was told, look, that diversity on the police force is an incredibly important part of making an effective police force because of who they're protecting in the population. There you go, in this middle one. If you use race alone, it is discriminatory, but if you use race as part of and consider in individual evaluations, it might not be. The more recent one was Fisher versus the University of Texas. The court has upheld the University of Texas's affirmative action program, and again has argued in this case that there is an interest in achieving diversity in the undergraduate program. Okay, and that's an interesting idea. I mean, it makes a lot of sense, especially in the Pettit versus Chicago one, but I can understand the compelling argument that might be involved in this. Here is some of the major employment laws, and we're going to kind of go through them one at a time. So we'll just have you just spend your time all you want there. No. Here, interesting. Religion in the workplace. This is a newer thing that's been coming up lately, and it came to the head when you had the day after pill. Okay, the day after pill, which was it's a fairly new a fairly new invention, and pharmacists that would refuse to prescribe the day after pill because of their religious beliefs against abortion. And several states have issued laws that prohibit pharmacists from doing this. But unfortunately, in most parts of America, a pharmacist is free to reject your prescription at will if they believe it's an immoral thing. Burwell versus Hobby Lobby, you find the same thing, that Hobby Lobby was founded by the Green family, and they're very religious, and they were long story. But anyway, the court upheld the idea that the business itself was allowed to hold religious values. I remember what it was. It was under the Affordable Care Act that they were required under their insurance plan to provide birth control as part of their health care plan. And they said, no, we morally and religiously object to this, so we shouldn't be required to do so. Right? And the court upheld them. Okay, that was interesting. Here in the EEOC versus Abercrombie and Fitch, there was a Muslim woman that went to Abercrombie and Fitch to get a job, and she was wearing a headscarf at the interview, and she was told, no, employees do not wear hats. You can't wear hats to work, so you can't be hired. Okay, and they came down on the side of the Muslim woman that was at the center of that case. Hey, I did that. The Equal Pay Act. It's illegal to discriminate in pay or benefits on the basis of gender, right? If jobs are equal. But this has been very controversial in the courts. What do you mean by equal? What's equal work? And so in one interesting case here, Brennan versus Prince William Hospital Corporation, rather. What happened was male orderlies were being asked to do an additional job that female orderlies were not, and that flip patients, which of course requires a lot of muscles. And the males were getting higher salaries. And so the court came down and said, yeah, okay, they have a little bit different responsibilities, but that's not enough to justify the difference in pay. In order for things to be, even if they're different by a little bit, are still considered to be equal work. The Lilly Ledbetter Fair Pay Act is a more recent act, which I don't remember the details on it, but it basically says for all lawsuits, there's a 180-day statute of limitation, and it changes it such that you can sue for discriminatory acts by a company well beyond the 180 days if you can show that it would have affected an ongoing paycheck, essentially. It would have affected ongoing. The Civil Rights Act of 64 and amended in 91. It was an attempt to decrease discrimination, right? It was Lyndon Johnson's thing, actually. I'm impressed with this coming out of Lyndon Johnson. But really, it was it prohibits discrimination based on race, color, religion, national origin, etc. Okay, so in some cases that have been up against the Griggs and Duke Power, even if a company did not intend to discriminate, if the adverse impact exists, then you must demonstrate that the selection battery, every single element is job related. Okay, even if there was no intent, and that's a key. Even though you don't intend, if you create a discriminatory outcome, you're responsible for it. The court ruled that items used to validate an employment requirement must be job related. Okay, that makes a lot of sense. The Civil Rights Act prohibits discrimination based on national origin and because of ancestry, culture, birthplace. In post 9/11, this has come up a lot because there's been a lot of backlash against Muslims based on this, but also things such as accent, religion, or even pregnancy. I don't know about pregnancy as a civil rights issue, but yeah, could be. Sexual harassment is prohibited under the Civil Rights Act, and there's a distinction between quid pro quo sexual harassment and hostile work environment. Quid pro quo is this for that. That's a literal Latin translation, but it's you give me this sexual favor, and I will give you that opportunity at the job. So it's, this for that. I trade you this, you give me that. Hostile work environment is perhaps not necessarily including actual acts, but instead hostile comments and environments. Okay. Oh, the sexual orientation is not covered under the Civil Rights Act. Okay, their sexual orientation is not protected, not a protected class at the federal level. Okay, but 22 states plus the District of Columbia have state level protections of sexual orientation, and in those 28 states that do not have it, 100 plus municipalities cover it. So on the federal level, it's not covered, but well over half of the country is in fact covered if you look at non-federal rules. Oh, wait, what is this? Oh, I did that. I did that. Yeah, executive order. I don't know that one. Prohibits job discrimination for contractors, subcontractors. Yeah. Okay. The Age Discrimination Act. And again, we need to remember that BFOQ, bona fide occupational qualification. So the Age Discrimination Act, it protects people that are 40 and older from discrimination. But in some cases, like the EEOC versus University of Texas Health Science Center, they had security guards at the Health Science Center, and they said can't be older than 45. And they were, sued for discrimination. But they said, no, age is a bona fide occupational qualification because security guards are being asked to patrol risky areas and do dangerous things. And in similar cases, there is now a standard rule. Airplane pilots, that is to say, for airline pilots need to be under age 60. It's the rule of 60, and it is not discriminatory if it is a bona fide occupational qualification. I love that, bona fide occupational. All right. And just kind of must demonstrate that. Yeah. Okay. You can read that. The ADA, a relatively recent newcomer here, prohibits discrimination against qualified individuals with disabilities. Disabilities in 1990 were defined kind of funky, but this is the way they were defined. Having a physical or mental impairment that substantially limits one or more life functions. That's kind of a broad definition. Having a record of such impairment, regarding as, sounds like lawyer speak to me, okay? And so we find that the Americans with Disabilities Act distinguishes qualified individuals. Qualified individuals are those who can perform the essential functions of a job. Okay, essential functions are those tasks that are significant and meaningful. So, taking a look at the little box on top, if a job involves heavy lifting on a very regular basis, someone with a bad back can be, no, we won't hire you, you have a bad back. It's not discriminatory because heavy lifting is an essential component. However, the notion of reasonable accommodations says if a job occasionally requires some heavy lifting, then a person with a bad back cannot be kept out. The company is expected to make reasonable accommodations, and in those limited cases where lifting is required, an alternative employee will do the function. Okay, so reasonable accommodations is an interesting idea, but it's kind of, what does reasonable mean? That's a kind of a strange thing. What is reasonable to one is not necessarily reasonable to another. And so what has come down in this notion of reasonable accommodations is the idea of undue hardship. So employers are required to create these reasonable accommodations, but only to the degree that it does not create undue hardship for the organization. Okay, that it doesn't undue hardship with respect to the implementation or expense. And I mean, again, you just substituted one problem, what's a reasonable accommodation, for a second problem, what's an undue hardship. And so I remember I was in Carnegie Mellon University in Pittsburgh, when they were told they needed to comply with the Americans with Disabilities Act. And the problem was is that the building I was in, I was like on the third floor, and it was a half a mile long. I mean, I'm not kidding you when I say it's a half a mile long. This building just went on and on and on, a straight line. But the problem is, it was built along a slope. Okay, so if you take a ball and set it down at the top, it would just roll for a mile or what, a half a mile down the hall. Okay, well, what the way the building was built was, in order to prevent it from being horribly sloped like this, as badly as it might be, they made it relatively level, and then 3 steps, and then 10 or 20 feet of relatively level, and then 3 steps. Okay, and so all the way down it was just 3 steps level, 3 steps level, 3 steps level, 3 steps level. And so then what happened was they were required to make this ADA compliant. And what they did was they installed a series of elevators. But they weren't elevators, they were lifts. They were lifts, okay? So that it would lift you up or down the 3 stairs. But the problem is if you were in a wheelchair and you needed to get, and I know how many elevators there were. There were like 4 real elevators in the building to get you up. And so if you needed to get from one end of the building to the other end of the building, I don't know how you're going to do it, because it would take you 3.5 hours, all right? But hey, they provided the accommodations, right? 3.5 hours to make the trip from one end to the other. And so I don't know if the university might have said that's an undue hardship on everybody, but yeah, it wasn't. Okay. Blah, 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 blah. ADA, okay, yeah, the ADA, no, here. The ADA updates in 2009 tries to expand what it means by disability. I think, I guess I can give my opinion, but now we hear all of this controversy with comfort animals and whatnot on airlines. I think perhaps the definition of disability has gotten so broad as to be anybody. If you want to say you have a disability, you just say I have a disability, and it is so broadly defined that anybody can justify such a thing. I don't know. We'll just leave it at that. The Family and Medical Leave Act allows employees to take job-protected unpaid leave for 12 weeks. Unpaid is unfortunately the key word here, but unpaid leave for 12 weeks because of things such as birth, health conditions of themselves or a family member. California requires 6 weeks of paid leave. Now that's cool, but that's California. They pay more taxes, but you get more for it, right? And the idea is that employees have the right to return to the same position or an equivalent position with the same pay or benefits. And I mean, clearly this is, quote, fair, but can you imagine this from the point of view of a company? You've got somebody with a serious medical problem. They're going to take 12 weeks off, okay? Meanwhile, you, the company, have to fill that position now, don't you? And you get a perfectly good employee in that position. And then all of a sudden, your regular employee is back from their medical leave. And they're like, hey, guess what? I need my job. And it's like, but it's filled. There's no position. There is no equivalent position. So it's not as easy as it feels, even though it sounds really fair to protect your job when you're sick. And it really is fair. It really does create some ramifications down the line. Back in 2009, with a large number of veterans returning from wars, there was a revision that provided extended leave for the families of wounded soldiers, but it also clarified what constitutes a serious health condition, which is probably a good idea. And this is a good thing to have. All right, so we'll stop there, and you guys will get ready for an exam, right? Not me, I'm on break. All right, no, we will see you though after your exam. So go enjoy that for now, and I'll talk to you after that.